Hi, today I wish to discuss with you all Aquilian action. In my last lesson, I introduced the law of delict, and in that, I stated that there are two types of delicts under the law of delict, namely damnum injuria datum and injuria. Aquilian action is action available for damnum injuria datum. So let us discuss in detail about Aquilian action. So, what is an Aquilian action? It is the action for damnum injuria datum, and it provides a general remedy for damage to property, physical injury to a person, and any other wrongful act causing pecuniary loss. This means if a person has suffered damage to property, or he has been physically injured, or he has suffered pecuniary loss, that means financial loss, because of negligence of the defendant, then his remedy lies in an Aquilian action. So, in order to establish a defendant's liability, the plaintiff has to prove three things: a wrongful act committed by the defendant, pecuniary loss for the plaintiff, and fault on the part of the defendant. Let us discuss these 3 points in detail. A wrongful act is basically an invasion of a legally protected interest of the plaintiff. This means the plaintiff has to show that the defendant has invaded one of his legally protected interests. This includes all the rights of the plaintiff. If he can prove such an invasion, that means the defendant has committed a wrongful act. But we have to remember, generally there is no liability for mere omissions. A mere omission is something like this. If A falls into a river and B walks past him, in that instance, there is no legal obligation upon B to render assistance to A. So, even if B walks by without doing anything, he will not be liable and it is not a wrongful act. So, generally, there is no liability for mere omissions. However, in some exceptional circumstances, an omission becomes actionable as a delict. These instances we will discuss in detail in another lesson. The second element that has to be proved by the plaintiff is pecuniary loss, which is also called as damnum or patrimonial loss. The rule is that the plaintiff has to prove loss which is capable of monetary assessment. If he has suffered a physical injury or a property damage, he has to prove that the loss is capable of being monetarily assessed. Loss could be accrued or prospective. For example, if the plaintiff has suffered a physical injury and he has incurred expenses to cure the injury, those are called accrued losses. And if as a result of the injury the plaintiff is unable to engage in his usual profession, then he has prospective losses in the future. So all these are taken as pecuniary losses. However, there are exceptions for this rule. Firstly, where a plaintiff has suffered pain and suffering as a result of a physical injury, he will not be able to monetarily assess the pain and suffering that he had to go through. In such an instance, the court will award damages for the pain and suffering without any monetary assessment. If you go through the case of union government, there the plaintiff claimed damages from the defendant for the pain and suffering that was caused to him as a result of the loss of his wife. Here the court held that there is no physical injury which resulted in pain and suffering. Therefore, the court did not award compensation. So we need to remember that this exception applies only where the pain and suffering has occurred as a result of physical injury. Where there is no physical injury, there will be no compensation. Secondly, where the plaintiff comes to courts to establish a right denied to him by the defendant and not to claim compensation, there the courts will not monetarily assess the loss caused to the plaintiff, but he will only be given nominal damages and he will be allowed to establish the right denied to him by the defendant. The third element to be proved by the plaintiff is fault on the part of the defendant. To prove fault, the plaintiff has to prove two things, namely dolus and culpa. We will be discussing in detail about dolus and culpa in later lessons, but for now we will have a brief understanding as to what is dolus and culpa and what the plaintiff has to prove. Dolus is basically willful and conscious wrongdoing. If a defendant has willfully and consciously done something wrong, it is called as dolus. To prove this, there are three elements to be proved by the plaintiff. Firstly, intentional act, that is, an act which the defendant has intentionally done. Secondly, knowledge that the act will cause harm to the plaintiff. Thirdly, duty to refrain from committing the act. Although a defendant has committed an act intentionally with the knowledge that it will cause harm to the plaintiff, but if there was no duty to refrain from committing the act, then there will not be dolus. So these three elements should be there in order for the courts to accept that there is dolus on the part of the defendant. Culpa can be defined as the conduct which involves an unreasonable risk of harm to others. So, if a defendant has failed to exercise the degree of care which the circumstances demand, in that case he will be held to be negligent. In the case of Blythe versus Birmingham Waterworks Company, the courts gave a definition for culpa. Here, the courts used an objective test to define negligence. Negligence is the omission to do something which a reasonable man would do and doing something which a reasonable man would not do. So this is solely relying upon an objective test to determine whether the defendant is negligent or not. However, there is no liability for negligence unless there is a legal duty to use care. This means the same act may be negligent in relation to A but not negligent in relation to B because the circumstances of the case, a duty of care may have been owed only to A and not for B. Therefore, the same act can be considered as negligence and in one circumstance, and in another circumstance it will not be negligence because it depends on the existence of a legal duty to use care. You can go through the cases of Pasgraf and Bohill versus Zion, and I'll be talking about these cases in detail in my later lessons. So basically what the plaintiff has to prove is that the defendant owed a duty of care to the plaintiff and that the defendant is in breach of that duty. So if I summarize the whole Aquilian action lesson, a plaintiff who goes to court in order to claim compensation for pecuniary loss that he has suffered has to prove three things, mainly a wrongful act on the part of the defendant, a pecuniary loss that the plaintiff has suffered, and thirdly, fault on the part of the defendant. So, in order to prove fault, there are two elements, dolus and culpa. We will be talking in detail about these dolus and culpa in my next lesson. So, thank you for watching the video. I hope to continue this lesson in my future videos. So like and subscribe for more lessons. And also if you have any legal principle that you want me to discuss, you can always mention that in the comment section. Thank you.